Good morning, good afternoon, good evening, and good night. My name is Brett Tishler. I'm a partner at White & Williams in the Workers' Compensation Subrogation Department in Philadelphia, and this is part two of the podcast. I'm presenting with my colleague here, Big Mike Abed. Say hi, Mike.
Hi, Mike.
This is part two of the Help Me Help You, how working with Claimant's Counsel can maximize your lien recovery. Part two, the investigation. In trying to put more energy in these podcasts so our 7 listeners, Mike's mom, can stay awake, I've been watching Only Murders on Hulu, and they're making their own podcast. And it's very interesting how they do it because they do it in Steve Martin's closet. And they're making things up as they go along. We're trying not to make things up as we go along. We actually have a pseudo script here as we talk about workers' comp subrogation. Part one, we spoke about what is workers' comp subro. Why do we want to work with the Claimant's Counsel or the Injured Workers Council to maximize lien recovery? How does that work? We discussed the adversarial process between the workers' comp subro professional, the employer, the injured worker, plaintiff's counsel. We discussed all that stuff, the players, the process, and how we want the claimant to get $1 billion in the third-party case because we want our lien. And we discussed how we need to make ourselves indispensable. So instead of them arguing about paying our lien, the third-party counsel wants to pay our lien. And
how do we do that?
How do we do that? We make ourselves indispensable. Exactly. So we're going to talk about the investigation because this is really where we make ourselves indispensable. Now, remember, accident happens, and especially if it's on the insured premises, but whatever, the accident happens, and typically the work comp carrier is the first to find out about an accident, right? The employer is making that call. Johnny went to the hospital. I don't know what happened. He broke his leg. He was working with a machine. He was driving a car. He stuck his hand where we told him not to stick it, whatever, but he's in the hospital. Workers' comp figures out, hey, this is a pretty serious accident. This guy broke his leg. He got a hand degloving. Does anybody know what a hand degloving is? Kate, do you know what a hand degloving is? It's exactly what it sounds like. Picture a glove, but it's your skin, and it's literally degloving it, taking it off. They hurt. And
now, for those of us who haven't vomited.
So, but a lot of times that this is how we determine how bad is a case going to be. What do we need to do, right? This isn't there was a fender bender and Johnny's back is hurting him. We're not going to pull out the presses, call the experts, go on and do a full court press investigation. But when little Johnny has a handy gloving or breaks a leg, this is where we know that he's going to have a lot of medical. He's going to have a lot of wage loss. So we need to be taking this seriously. So workers' comp finds out, they get it to subro, and hopefully if everyone's doing their job right, we are contacted, or the workers' comp subro professional is aware of this loss within hours or days, or if not hours after the accident happens. So now that we know that, now that we've got boots on the ground, we're one of the first people, what do we do? What do we do, Mike?
Well, the specific step is going to depend on where the accident itself happened. But the crucial steps are always going to be gather the facts, preserve the evidence, speak to the witnesses. Now, where we get those facts or those witnesses is, as I said, going to depend on the specific facts of the loss. Has the loss happened out on the street? Has it happened at the employer's premises? Has it happened, oh no, on the premises of a potential target? Now, depending on where it happened, it depends on the instrument we have available. Where it's happened on the employer's premises, we can reach out to the employer, work with them to get all of the material facts, to get any surveillance video, to speak with the right witnesses, to understand if there was a machine involved, and if a machine was involved, where the machine came from, when it was purchased, who made it.
Now, I will say, you did a very spectacular synopsis there, and I want to break something up, though. You're right. Gathering evidence, gathering facts, preserving evidence, speaking to witnesses, all very critical. Very easy to say in one sentence, but let's break it up. The first thing is, most times when you're talking about a product loss, for example, a machine failed, which resulted in a worker getting hurt, most times it's happening on the insured's premises. Either way, the insured, the employer who reported the claim, they're going to be our first source of information. So it's critical that they understand who we are. They understand the role of workers' compensation subrogation and what the subro adjuster, what subro counsel is. So this is where the carrier, it's critical that the carrier explains to the employer, hey, this is part of the process. You're going to be contacted by a workers' comp subro professional, John Smith, or our attorney, Mike Abed, or Brett Tishler, if you're really, really lucky. But they need to know, they need to be part of the process, the employer, because if we get a recovery, it only helps the employer, brings their mods down, right? I always say to make it, depending on who you're talking to, you could have a big time employer with a big multinational employer. They know what workers' comp subro is. They know what subrogation is. They're savvy to it, and they might be very willing to help you. They might not. They might not care. Or you might have a small company who has no idea what subrogation is, never even heard that before. Subro what? And they've never had a worker get hurt to the point where they even had to file a work comp claim, or one at least that merited an investigation. So you've got to really got to hold hands with them. You have to be very careful in what you're doing, so you're all on the same page. They need to know that, hey, we're here to help you.
In other words, help us help you.
Exactly. That almost sounds like it could be the name of a podcast. So once, hopefully, when you call your employer, I know we get a case, and we always make it a rule that we tell our clients, hey, we need to contact the employer, but we let us know when you've told the employer to expect a call from Mr. Mike.
And Brett, I'm sure you've been on that call when you're the first person to be reaching out to the employer about subrogation, and you can tell from the way they answer the phone. Who are you? What are you doing? Why is a lawyer I've never heard of calling me? And that is not an investigation off to a good start.
Exactly. And it just causes delays. So this is all part of, if they're aware of who we are, it just makes things go so much better. So once they get to the point where they know who we are, now it's a lot of times after I've introduced myself, and again, no matter who you are, if you're the attorney or the subrogation adjuster, you need to know, who's your audience? Is this involving just a bad accident or a fatality? Is this a small company that's taking it very, they're emotionally, they're drained, they're shocked. You can't just launch into what you need. So a lot of times I call up, I discuss it with the employer, I tell them who I am and what I'm looking for, and then I follow up with an email, because 9.9 times out of 10, the employer has no information and they have to look it up. Or I'm talking to the HR person and they go, well, you really need to talk to the maintenance technician, or you really need to talk to our EHS person who's not here. So I send an email that follows up that phone conversation. And what is it that we need? It depends on the case. But typically, if it's an accident that occurred on the employer's premises and involves some type of machinery, for example, we need access to the premises. Let us onto the law site. We need access to witnesses. Well, are there witnesses first, but we'd like to speak to them? Is there security footage? Can you show it to us? Is there pictures of the machine? Is there any type of investigation that you, Mr. Employer, did? You'll find that a lot of the more savvy employers, they have their whole investigation process. They have a whole that they do on their own. And you're going to want copies of that. You're going to want access to documents. For example, did this happen on a construction claim? Are there contracts? Are there purchase documents for the machinery involved? Are there maintenance documents for the machinery involved? Does a third-party company come out? How old is the machine? Right? That's one of the most critical things, depending on the state you're in.
Has it been modified since it was installed?
Has it been modified since it was installed? There are so many things going on here. And remember, we're getting all this information. We're the first on the ground. This is hours or days after the accident happened. This is the best time to identify witnesses, to identify all this stuff. Injured worker finally gets his attorney, which could be a month from now, 6 months from now, a year. Witnesses don't remember things. They walk away. The EHS guy, which is environmental health and safety, the EHS guy is no longer at the company, and he's the one that did the whole investigation. All that stuff could be gone. So now it's strike while the iron's hot. This is the early intervention is the best opportunity for recovery. It's the best opportunity to help us help Claimant's Counsel.
Now, Brett, you recently worked on an aluminum smelting case. What happened with that?
Oh, Mike, it's almost as if you were prompted to ask me that, but I will tell you. We had a great example of all this is We had an aluminum smelting plant loss. A guy basically, it was a plant that took scrap aluminum and melted it into molten aluminum so they could make sowls and ingots and other things, which would then be used to make whatever any other company wants to make. And what they would do is they would get all this scrap aluminum in bales, and it looked like hay, but it was aluminum. And they would they would dump it into a furnace. It's called charging the furnace. And as they would charge the furnace, it would melt, and they would just keep on charging, and that's what you would do. Well, what happened on this particular case is a man was charging the furnace. He had a dump truck, and he was charging the furnace, and there was wet material, unbeknownst to him, inside this bale of aluminum, the scrap aluminum. So when it went into the furnace, it caused a big explosion, huge explosion, and resulted in significant burn injuries to this worker, and ultimately he died because of those injuries. Now, we got the case, I think, 2 days after it happened. And the insured, the work comp carrier did a fantastic job of telling the insured who we were. And the insured, the person I met with, understood our role, understood how it benefited them because this is going to be a huge claim. And they were fantastically cooperative and responsive because it ended up going into litigation, and we ended up we had to intervene on behalf of the carrier, and we ended up representing the insured as a non-party to the litigation, and we had to go through thousands of pages of discovery that we got from the employer. We had to go through prep almost a dozen witnesses for their deposition. We had to go through surveillance footage. We had to go through witness statements, all stuff that they gave us as soon as they could find it, days after the loss. And it was only through, and this accident happened in Alabama where it's 1% you lose for the plaintiff, and it's only through the help of the employer that providing us all this information that we were able to provide to plaintiff's counsel. So they knew exactly where all the pitfalls were, that we were able to help them secure a significant, very significant 8-figure recovery, which led to 100% lien recovery. And it was only because of the cooperation that we got from the employer that we were able to help the attorney. So that's a great example of investigation and helping us so we can help the plaintiff's counsel.
What do you do in a situation where the loss happens outside of the insured's premises, say either on the street in the public area, or, as I say, God forbid, at the target location owned by the target?
Great questions as well. A lot of things, other areas of information, for example, public sector, OSHA, things like that. You want to issue FOIA requests, Freedom of Information Act requests, as soon as possible. That's number one. Number two, when you're dealing with a loss that occurred outside of your premises, we don't have control to it. You want to issue preservation letters immediately. Because if you have, I'll give you a very simple one. Let's not talk product liability. Let's talk slip and fall. You got a guy who slips and falls at a truck stop. You want to get that preservation letter out immediately because maybe there's a surveillance footage that has the whole thing. Maybe there is a loss report that somebody wrote, and who knows what their document retention is. You need to get that out there immediately because if they don't have that letter saying preserve this information, maybe the security tape gets written over. Maybe that loss report isn't handled properly. Who knows? All things you could lose. If it's a trucking accident and it's not our truck, we don't want them to fix the evidence. We don't want them to alter the evidence. We need to look at it. You need to get those letters out because guess what? If they alter the evidence in spite of us sending us that letter, we've at least protected ourselves because we could potentially go to court and get a spoliation argument. Now,
which brings us to the last piece of the puzzle, which of course is making sure that you have the right expert to review whatever evidence you do get. You don't want to be in a situation where you've retained the wrong expert or an expert who's not qualified enough to handle the loss. And, an extreme case spoliates the evidence themselves because they don't recognize the significance of it.
Exactly. So you got to watch out for the jack of all experts. You got to get the right experts. Okay. If you can't put the entire puzzle together, at least let us gather the pieces because Claimant has the rest. He's going to come in there and the attorney's going to say, I got a case to pursue. But here, we've got this gift wrap investigation that we can help us help you get our lien recovery. Now that just brings us to the end of part 2. So listen to us next time on part 3 of Help Me Help You, how working with Claimant's Counsel can maximize your lien recovery, as we discuss how the help provided gets us to successful third-party litigation and workers' comp lien recoveries. Thank you.